My name is Rob Morris. I'm with the Estate Planning Department at Stark & Stark. Oftentimes during the course of my representation of clients, I receive questions regarding what are the fundamental estate planning documents and what are issues that are associated with them. Recently, we've been receiving a lot of questions in this regard, so it's a good time to go ahead and review them. The outline of this presentation includes what is estate planning and why is it important? Why should clients be considering estate planning and what issues are associated with not doing it? What are the fundamental estate planning documents that all individuals should have? And what makes each of these documents important for clients? Lastly, we'll go over important considerations associated with each of the documents and some consequences for not having the documents in place. So first of all, what is estate planning? Estate planning is a process that involves putting into place legal documents to protect you and your loved ones. And that's an important issue. A lot of times people focus on themselves with regard to estate planning, and they don't consider the impact of not having these documents on their loved ones. So just think of this. If I don't have a power of attorney, or I don't have a medical healthcare proxy, what happens to my family and what happens to my loved ones if these documents are in place? The estate planning documents themselves allow you to nominate individuals who are frequently family members to act on your behalf with regard to legal, financial, and medical affairs during your lifetime, and in particularly if you're disabled or incapacitated. Again, this is an important consideration. If you're incapacitated, you're going to continue to have bills coming due. You're going to continue to have issues that arrive in the course of your life. These have to be dealt with, and if there's not a process put in place to deal with them, it could create issues for the management of your affairs. And lastly on the slide here, estate planning documents also allow you to control to whom and how your assets are distributed upon your death, as well as the agents that are going to administer this process. You know, one thing to consider in that regard is if you don't have a will, by the way, the state of New Jersey has a plan for you. And unfortunately, that plan may not match with your intent. So it's very important to have these documents and estate planning done in general. Okay, what are the fundamental estate planning documents? So everybody's individual circumstances differ. So the terms of the documents may vary a little bit. And some people need trust, which you see referenced on this slide. Some don't. But for every client, at a minimum, they need to have in place a power of attorney for healthcare, a power of attorney for financial and legal matters, as well as a will. And equally important to having these documents in place is the documents themselves have to be properly drafted. If the documents are missing terms or contain restrictions that don't really match present circumstances, it can create problems for you, it can create problems for your family. And almost as important is the fact that the documents have to be executed properly. And what I mean by that is they have to be signed, and there's certain formalities that go along with the signature for each of these documents. And if those formalities aren't followed, it'll do one of two things. It could possibly invalidate the document itself, or it can result in additional hurdles in having the document recognized. And when we talk about hurdles, just translate that into additional costs and delays for you and your family. So the first document we're going to talk about here is healthcare proxies or advance directives for healthcare. These documents are designed to address medical decisions. Now, by statute, the document covers two primary areas. The first part is a proxy directive, and that's the appointment of a healthcare representative to make decisions for you in the event decision-making capacity is lost. The second important part of this document is the instruction directive. These are actual instructions that you provide to your healthcare representative and your healthcare providers regarding medical treatment and care under certain circumstances. So those are the two main components of a healthcare proxy. Now, there are issues associated with each of them. With regard to the healthcare representative, it's important that you appoint somebody that reflects your priorities intent with regard to decision making. So oftentimes clients will say, oh, go ahead and appoint a spouse, right? Well, it's important to speak with your spouse and your other agents so they understand what your intent is with regard to medical decisions if you're not available. And with regard to some agents, in particular the alternate agents, clients oftentimes want to think about who they choose to be their alternate agent if the spouse isn't available, simply for this reason. They want the agent to reflect their priorities and intent. So that's an important issue when you're choosing agents. An equally important issue is the agent's age and availability. So you're doing this document because you're concerned about your possible incapacity and you're unable to make decisions on your behalf. We have to make the same consideration with regard to your agent. So if you appoint, for example, an agent that is older and you expect that the healthcare representative and the document will be around for a while, that may be an issue. You may outlive your agent, in which case you need to make sure that you designate an alternate agent. A related issue is availability. Some agents have difficult availability, and that can be for a variety of reasons. The most simple one is geographic distance. So if the agent's a long way away, and there are other people that may be available to serve as agent that are closer, well, you need to weigh that in the choice of your agent. So these are all important considerations when choosing a healthcare representative. The next document we're going to talk about is a power of attorney for financial and legal matters. A power of attorney is a document whereby the principal authorizes another individual who's known by statute as the attorney in fact or agent, who's going to go ahead and make decisions on behalf of the principal. So therefore, the choice of the attorney of fact is critically important for this document because of the broad authority that's granted by the power of attorney to the agent or the attorney in fact. All right, so we'll talk about that in a little bit. The document itself has to be properly drafted. All right, so the first thing is the document actually has to be durable. I've actually seen some powers of attorney that expire if the agent becomes incapacitated. Well, that essentially defeats the whole purpose of doing the power of attorney in the first place. So the document has to be properly drafted to reflect the fact that it is a durable power of attorney, which will remain in effect even if the principal becomes incapacitated or disabled. A related issue is the passage of time. Now, this isn't a legal issue, it's more of a practical issue. We've seen where some financial institutions raise questions about powers of attorney, particularly if they're more than 5 to 10 years old. So that may delay the implementation of the power of attorney, or cause other problems in having the power of attorney recognized. So if your power of attorney is older, you may want to consider getting a new one just for that practical reason. There are a number of issues that go along with the actual agent. All right, so it's important to consider who you're going to appoint as your agent under the power of attorney. And that primarily is because of the agent's decision-making qualities. Okay, the agent's going to be granted broad authority under the power of attorney. So it's really important to choose a quote unquote competent agent. So I put that in quotes because we're not really talking about legal competence here. We're actually talking about whether the individual is good at making financial decisions. Is the individual good at making legal decisions? Surprisingly, in many cases, the answer to those questions is unfortunately no. And that can be for a variety of reasons. Sometimes the agent just isn't good with finances. Sometimes the agent gets nervous or doesn't want to act on others' behalf. So it's really important that you designate an agent under a power of attorney who's able to engage in this type of decision-making process and do it in an efficient and appropriate manner on your behalf. Now, as we saw with the medical power of attorney, the age and availability of the agent is also important. Is the agent himself or herself at risk of being unavailable? We see that with some of our older clients. In particular, they may want to appoint a spouse who's also older. Well, that's fine, but you'll also have to then go ahead and designate an alternate agent if your primary agent's unavailable. And lastly on this slide, there can be multiple agents under a power of attorney. Those have to be specified in the document. So what we mean by that is you can actually have more than one agent appointed at the same time. If you do that, it's important to specify whether those agents can act jointly or severally. So what we mean by that, if they're required to act jointly, that means that all the agents have to agree on each decision. Conversely, if they're authorized to act severally, that means they can act independently. So each of the agents can go ahead and individually exercise all the authorities that are granted under the power of attorney. This is important. So for example, if you want to do a routine transaction, hopefully you don't have to have all the agents sign a check, for example, or you don't have to get all the agents to go ahead and sign a routine contract or pay a routine debt. We don't want to have to force all the agents to come together and act jointly oftentimes. Now, it can be an issue if your agents are geographically spread apart. So you have one agent in one state and another agent in a different state. It may be difficult for them to act jointly. So that's an important consideration on a power of attorney. Equally as important on the power of attorney is the drafting of the document, and specifically the scope of authority that's granted to the agents by the document itself. Generally, we like to see the powers of attorney as broad as possible. The reason for this is it's difficult to anticipate future circumstances. So if we start imposing limitations on the agent in the document, it's possible that one of these limitations may come back in the future and cause problems. So in general, we want to try and make the scope of authority as broad as possible for the agent. In that regard, gifting of assets is a very important authority to consider in any power of attorney. I've seen this done in different ways. Some powers of attorney don't authorize gifting at all. Other powers of attorney limit gifting to the annual exclusion amount, currently $15,000 per person per year. Other powers of attorney tend to allow broad gifting authority. Now, that's going to depend on individual circumstances and the preference of the principal. But it is important to consider two things. So if you're considering elder law planning, which is possibly using or employing Medicaid to assist in paying for a nursing home, or you want to do any type of involved tax planning, and you don't have broad gifting authority in the power of attorney, well, you may have just handicapped yourself or prevented yourself from doing this type of planning. So it's important to consider gifting as part of the scope of authority in the power of attorney. And lastly, on the slide here are electronic accounts and records. As we all know, many people are shifting their accounts to electronic formats. In some instances, the individuals are not even receiving paper statements. So everything's done electronically. So the power of attorney should specify that the agent has authority to access these accounts, which is very important, as well as do transactions on these accounts. If that's not spelled out in the power of attorney, that could pose issues for these types of accounts later. All right, let's talk a little bit about what happens to you if you don't have a power of attorney or a healthcare proxy. Well, the primary alternative is a guardianship hearing. A guardianship hearing involves a number of issues. So even under the best circumstances where the court's ready to hear the case, there's not a lot of issues regarding the person's incapacity, and the family gets along well, there's still delays. You have to file a complaint in the court. The court's going to appoint counsel to go speak with the alleged incapacitated person, and then everyone has to come back for a hearing. So that takes time, all right? And usually that's at least a month, sometimes longer, all right? So there are always delays. Naturally, as you probably guessed from some of the issues I just cited, there are costs that go along with it, mainly attorney's fees. So you're gonna have to pay for the court-appointed counsel. You're gonna have to pay to have the complaint filed and put together, and those can be expensive. And there are also expenses that continue even after the agent's appointed in a guardianship. Some too, right off the top of my head, are bonding, right? So that if you have money, your agent's going to have to be bonded. And it's probably a safe statement to say that the cost of the bonding is going to exceed the cost of a power of attorney or a healthcare proxy. And that bond has to be paid annually. Another related issue is that the agent, even after they're appointed, is going to have to file annual well-being reports with the surrogate and likely have to do annual financial reporting, which depends on the overall amount of assets of the alleged incapacitated person. In some cases, the annual financial reporting can be quite detailed. Okay? Another alternative to the documents, and this is only with regard to medical treatment, is a physician order for life-sustaining treatment. Okay? Well, the primary issue with the POLST is it can't be implemented if you don't have decision-making capacity. So that's the whole issue regarding these documents in the first place, and the reason why you want to get them done as soon as possible and avoid waiting and risking your subsequent incapacity. So the reason why you want to have a power of attorney or a healthcare proxy is because you're incapacitated. So if you don't do them and you just wait to go into the hospital and figure out I'm going to do a POLST, well, the issue may be moot anyway, because if you don't have decision-making capacity, you're not going to be able to do one of these forms either. So this isn't a good alternative to having the documents done. All right. The last document we're going to talk about is your last will and testament. All right. Again, every client should have a last will and testament in place. As everybody knows, the will governs the administration of your estate. Some of the basics include the payment of your debts, payment of any taxes left over from your lifetime. And if your estate has assets available for distribution, well, the will is going to set forth, or it should, who's going to receive those assets and in what proportion. The will also appoints an executor. So that's a fiduciary that's going to be responsible for the administration of your estate, the payment of all those debts and taxes that we just ran through. And then the executor is going to also be responsible for making the distributions from the estate. An important component of the will is that the executor's bond needs to be waived. For those individuals that have minor children, a really important component of the last will and testament is the appointment of a guardian. So minor children in New Jersey are individuals that are under age 18. Those individuals, really don't have legal authority to make much in the way of decisions on their behalf. So the guardian's going to do that for them. So it's a very important individual to specify if you have minor children. If you have an incapacitated adult child, so that's an individual 18 years or older, the will can also specify who you would like to have appointed for your adult child. Now, again, there'll have to be a guardianship proceeding, but at least the will come in as evidence as to the choice of that person. So that's an important thing to specify with regard to guardians. Obviously, the last will and testament is also important because it controls distributions to your beneficiaries. It allows you to name who those beneficiaries are, and the will also allows you to specify what proportion of the estate goes to each one of those beneficiaries. And where appropriate, a last will and testament can also contain testamentary trust. This is often done in particular for younger beneficiaries who are incapable of managing money, and you don't want to have a direct distribution to them. So a will can include a testamentary trust as well as the trustees that are responsible for managing that trust. What happens if you don't have a will? Well, if you don't have a will, New Jersey has a plan for you. All right, so New Jersey has what's known as laws of intestacy. Right? And those laws are going to specify who's going to receive your estate. Now that poses a variety of issues. You may not agree with the laws of intestacy or feel that that's the most efficient way to distribute your estate. Now, unfortunately, if you don't have a will, it's not something that can go back and be fixed later. A related issue is if you have children that are minors. All right, so if you have assets in your estate and you leave them to minors, well, guess what? They may not receive them. And in fact, what may happen is that the money may be deposited with the surrogates fund and held by the county surrogate until those minor beneficiaries reach adulthood. And so that creates two issues. Number one, they're not going to have easy access to the money while they're minors. And number two, if it's a significant amount of money, when those beneficiaries reach age 18, they're going to receive the full amount. We all know what we were like at age 18. There are very few of us that probably could manage that money as efficiently as perhaps a trustee or another family member. So that's two issues there if you have minor beneficiaries in your family. A related issue with intestacy is the appointment of the administrator. So that's sort of the equivalent of an executor under a will. The administrator is the person that's charged with managing and administering your estate, paying expenses, and making distributions where appropriate. All right, so that individual is going to have to be bonded. And the cost of the bond, again, like a guardian, is probably going to exceed the cost of preparing and implementing a last will and testament. A related issue can also be potential delays and expenses. I'm currently involved in a couple of the states now where it's actually not that easy to appoint an administrator because we have to go track down all the family members that have a right to be appointed. We have to put them all on notice, give them the opportunity to object, and that results in delays and obviously expense in administering the estate over and above the bond. So bottom line is that intestacy is, it's a nice format that the states put in place for those that don't have a will, but you can probably do better if you have a last will and testament in place. All right. So in conclusion, and I wanted to keep this a short review just to go over the highlights. But there are basic documents that are important to maintain control and designate preferred agents for every person. Again, those documents are your healthcare proxy, your power of attorney for financial affairs, and your last will and testament. Unfortunately, if you don't have these documents in place, the alternatives, primarily guardianship and intestacy, result in uncertainty. They most likely will result in delays and extensive costs, which go well beyond the cost of preparing the documents themselves. And the other and last point is that failure to have these documents in place often results in unintended consequences for the family. I hear this many times when we're dealing with estates where the documents aren't in place. The family is, very upset over the delays that were involved. There are extra costs they're going to have to pay, and it places these decisions in jeopardy oftentimes. So it can result in problems for yourself while you're alive. It can also result in delays and hard feelings for your family if you don't have the documents in place. So that concludes this seminar. Again, we wanted to keep this a basic seminar. If you have any questions, you are welcome to call me. My direct number is 609-945-7617. Thank you.